Good morning, Your Honour. My name is Boyce, initials AO, and I'm counsel for the defendant, James Beatson. My client wishes to plead not guilty to the charges against him by the Crown. Firstly, I'd like to draw Your Honour's attention to three main issues on the facts of the case. And these are my client's backpack being opened by the police officers without a warrant, my client being interviewed in the police car and it not being recorded, and the interview at the police station where part of the interview was recorded but was inaudible. I put to Your Honour that my client was not treated correctly under the fairness discretion and the public policy discretion within the Evidence Act, namely at section 130, and in addition to this decision held in the Christie and the Australian case of Lee. Firstly, I'd like to draw Your Honour's attention to the public policy discretion. Specifically that the evidence obtained was done so unlawfully and therefore should not be used as evidence in this case. And I put to Your Honour that the officers in this matter have broken the law to enforce the law, and that's also not okay. However, I do appreciate that even though the evidence has been obtained unlawfully, it doesn't necessarily mean that it would be automatically excluded. Which brings me to my next point, and I refer you to Bunning and Cross, and will be relying on this decision in my argument. If we look at this particular case of Bunning and Cross, the fairness discretion will be applicable due to the cultural factors that are relevant here in my client's case. Namely the fact that my client did not make eye contact and he just agreed with the officer's questions. Indigenous individuals, my client included, tend to agree with people of authority to get out of trouble. He seemed to have no concept of what he was looking at when they were driving him around at the houses and asking him what he did. I put to Your Honour that the officers intimidated my client in the car and then intimidated him at the station when they told him to admit to the offences he did. So to try and escape the questioning, he has said, yes, I did it. My client was simply affirming what the officers were saying with him without substantially agreeing with what the officers were saying, which is similar to what he did at the station when he signed the confession, also similar to the situation in the Hasler case. This, Your Honour, in my expert opinion, undermines the probative value of my client's confession. Therefore, I ask Your Honour to accept that the fairness discretion should be exercised in this matter. I now put to Your Honour that the public policy discretion should also be exercised as, based on my client's instructions and the evidence on the case, the police have breached multiple sections of the Police Powers and Responsibility Act in order to obtain my client's confession. I refer Your Honour to section 420 of the Police Powers and Responsibilities Act, which provides that a police officer who wants to question an Indigenous person must offer legal aid. Based on the facts on this case, our client was offered a social worker. He was not privy to legal aid prior to questioning. And the social worker wasn't present in the car either when they were driving around. I note that there was no recording of evidence in the car, and in addition to that, the recording of my client's confession in the police station was inaudible in part. I refer you on to section 436 and recording of the interview. I note that if the person makes a confession or admission, it can only be used if it is recorded as per section 436. Therefore, I argue that there was a requirement to record my client's confession and it had not been complied with. If it was recorded, the record needs to be written and it needs to be read back to my client. Based on the facts, this was not done either. Your Honour, there is a number of breaches by the police in this matter, so clearly my client's admission was found unlawfully. I will now address with the court the factors outlining in Bunning and Cross as to whether this breach was a genuine mistake or a deliberate breach. The first factor given the number of breaches in conjunction with the severity of the said breaches from the officers, it implies on the facts that it was deliberate in a breach of the PPRA. This would count in favour of exclusion of the evidence. The second factor is if the breach is deliberate, then the court does not need to consider the cogency of the evidence unless it is essential to the Crown case. Given my client's confession and the items found in his backpack are the only evidence to the case, Your Honour, we will need to consider the cogency of the evidence we have before us. High cogency will mean it is less likely to be excluded. I argue to the court that my client's admission was obtained involuntarily given his Indigenous cultural differences and therefore is low probative value and so it would have low cogency. So this factor is in fact in favour of my client. The third factor the court needs to consider is whether the evidence is likely to perish or disappear, or the witness to run away, or if there was imminent danger of the evidence being lost, or have the officers just cut corners. I put to Your Honour that the officers merely cut corners. The officers could have made one phone call to comply with the legislation to get legal aid on the phone or to the location. The officers could have recorded the confession properly and recorded the confession of my client. It seems to be a cutting of corners for the sake of convenience here, so this would also suggest exclusion. The fourth factor is the gravity of charges, and I'll consider the importance of the protection of the community. While the charges against my client aren't minor, they're not extremely severe either, in that no lives were at stake in terms of danger to the community, and therefore this is more likely in favour of exclusion of the evidence. The last factor I will put to Your Honour is whether or not the police officers breached any statutes, which they did. As previously mentioned in my arguments, the police officers breached many sections of the Police Powers and Responsibilities Act. This act is in place to prevent or at least regulate police conduct in making sure the evidence is obtained properly and legally, and to prevent institutional power to affect members of the public in a negative way. So this would suggest exclusion. We've looked at all the factors here. So all the factors show that the evidence should be excluded in the public policy discretion. In conclusion, I put to Your Honour that the evidence in this matter would be excluded on public policy and fairness discretion. Thank you.